Hello, and welcome to BLR's HR Compliance News Update. I'm Steve Bruce, and there are dramatic developments to report on today. On August 27, 2013, the U.S. Department of Labor's Office of Federal Contract Compliance Programs, or OFCCP, announced a final rule that makes significant changes to the regulations implementing the Vietnam-Era Veterans Readjustment Assistance Act, or VEVRAA. VEVRAA prohibits employment discrimination against specified categories of veterans by the federal government, contractors, and subcontractors. Here, with a closer look at the new regulations and the implications for federal contractors, is BLR Senior Legal Editor and Affirmative Action Expert, Susan Schoenfeld. Welcome, Susan.
Thanks, Steve. For about 40 years, VEVRAA has required federal contractors and subcontractors to take affirmative action in their recruiting, hiring, training, and promoting of qualified veterans. However, the regulations never required covered contractors and subcontractors to conduct data analysis and set workforce goals or benchmarks, as they are required to do under the affirmative action requirements for women and minorities. Well, that all changed in August of this year when the final VEVRAA rules were issued by OFCCP. The new rule requires covered federal government contractors and subcontractors to collect data and take new specific action-oriented steps in order to comply with the final affirmative action requirements for veterans. Today, I'm going to discuss some of the highlights of the new final VEVRAA regulations. First, and perhaps most importantly, the new VEVRAA rule establishes hiring benchmarks for protected veterans. Contractors may choose to either adopt a benchmark determined by OFCCP, which is based on the national percentage of veterans in the civilian labor force, currently at 8%, or in the alternative, covered veterans can choose to set their own benchmarks based upon data derived from various published reports issued by federal agencies, including the Bureau of Labor Statistics and the Veterans Employment and Training Service. According to OFCCP, unlike hiring goals, benchmarks serve only as a yardstick to measure the success of outreach efforts. The new rule asks contractors to set benchmarks rather than goals because, quite frankly, the only data regarding veteran availability in the labor force encompasses all types of veterans and is broader than the subset of veterans who are protected by VEVRAA. Therefore, OFCCP reasons that such data cannot be used as the basis for establishing an availability-based goal. So the final rule does not require contractors to apply their hiring benchmarks to individual job groups. This is good news for contractors. What the final rule says is that contractors must apply the benchmark number only to the workforce as a whole by AAP establishment. Second, the final rule requires contractors to undertake new data collection activities in order to bolster and improve upon the data available regarding veterans and employment. Specifically, the new rule requires contractors to document and update specific comparisons and information regarding applicants and employees every year. With respect to applicants, the new rule asks that contractors consider and collect information on the number of protected veteran applicants, the total number of job openings and the number of jobs filled, and the total number of applicants for all jobs. With respect to employees, incumbents, contractors must consider and collect the information on the total number of protected veteran applicants hired, and the total number of applicants hired. The next significant change brought about by the new VEVRAA rule is designed to assist contractors in identifying who is a covered veteran. When the new rule takes effect, applicants must be invited to self-identify as protected veterans at both the pre-offer and the post-offer stages of the application process. For pre-offer identification, the final rule permits contractors to invite applicants to self-identify as quote-unquote protected veterans at the same time that the contractor collects demographic data regarding race and gender and ethnicity from applicants as required under Executive Order 11246. OFCCP has provided a self-identification form in the final regulations themselves. However, contractors should not begin using the self-identification form until after the effective date of the regulations, which we'll talk about a little bit later. Once all of the data has been collected, what does the new rule require that covered contractors and subcontractors do with that data? Well, to determine whether the contractor's outreach and recruitment efforts have been successful, the final rule requires that contractors annually assess their efforts and document the evaluation. The criteria must include the criteria that the contractor uses to evaluate the effectiveness of the contractor's efforts and the contractor's conclusion as to whether or not each effort was effective. The new rule doesn't spell out exactly how the assessment is to be done, but the consensus is that contractors should apply OFCCP's 8% benchmark figure to their data under what is called the any difference rule. If the contractor concludes that the totality of its efforts were not effective in identifying and recruiting qualified protected veterans, it must implement alternative outreach and recruitment methods. Contractors must retain their evaluations for 3 years, and this allows them to assess the success of their efforts over time. Some other important changes included in the final VEVRAA rule are the incorporation of a specific EO clause language for subcontracts. This language notifies contractors of their responsibilities and includes a specific reference to veteran status. In addition, the new rules speak to the use of electronic postings. When the contractor has employees who don't work at the contractor's physical location, OFCCP will now allow a contractor to satisfy the notice process and posting process by posting the EEO notice in an electronic format. The rule only requires that contractors provide employees with computers that can access the electronic posting, or that the contractor have actual knowledge that the electronically posted notice is accessible to its employees. Finally, I want to talk a little bit about compliance evaluations. The final rule cements OFCCP's position that it may obtain information pertinent to a compliance evaluation for periods after the date of the scheduling letter. This is better known as the Frito-Lay rule. The rule states that OFCCP may extend the temporal scope of an evaluation and examine after the date of the compliance evaluation scheduling letter, if and only if OFCCP deems it necessary to carry out its investigation of what it sees to be a potential violation of VEVRAA. Now, contractors must also inform OFCCP of the formats in which they maintain records and other information, such as Excel, PDF, and Word documents. And they must provide the records and information to OFCCP in the available format that OFCCP selects from the list of available documents that the contractor provides. OFCCP may also request that the contractor provide documents either on-site or off-site during compliance checks, and that the OFCCP may conduct focused reviews both on and off-site. Now, let's talk a little bit about the effective date of the rule. The final rule becomes effective 180 days after its publication in the Federal Register. As of this effective date, contractors must comply with all elements of the final rule except for the new Affirmative Action Program requirements in Part C. What this means is that contractors with an AAP in place on the final rule's effective date, which is projected to be approximately March 2014, these contractors with an AAP in place at that time may maintain that AAP until the end of their plan year, and they may delay compliance with the new requirements of Subpart C until the start of the next AAP cycle. Now, during the remainder of the AAP cycle, contractors are encouraged to begin updating their employment practices and IT systems to come into compliance with the revised requirements of Subpart C. And they're encouraged to do this as soon as possible. It's important to remember that contractors must comply with the other requirements of the final rule other than Subpart C. That is Subpart A, which pertains to the EO clause, Subpart B, for non-discrimination, Subpart D, the enforcement clause, and Subpart E, the record-keeping clause, must be in part and complied with by the rule effective date, which I mentioned before, is projected to be March 2014. So that's a very quick look at the latest developments in affirmative action for veterans. I'm going to send it back to you, Steve.
Thank you, Susan. For the latest information and updates regarding changes to the VEVRAA Regs, visit our OFCCP Regs for Federal Contractors Resource Center, which can be found at hr.blr.com/resource-centers. Also, be sure to watch our related video on the new OFCCP Regs for Section 503 of the Rehabilitation Act, which prohibits employment discrimination against individuals with disabilities. For BLR, I'm Steve Bruce.